the ANC has been dealt yet another legal blow. This time, the High Court in Durban has dismissed with costs its case against the Umkhonto Sizwe party. The ANC had argued that the use of the name by the new party amounted to passing off in common law, that is a misrepresentation of an association. Now, the party believes the use of the name by the new party would lead to voter confusion at the May polls. The governing party sought interdictory relief in the High Court. The party says it will appeal the judgment.
I'm happy that the ANC has been shown that they can't fight the MK. We are unstoppable. Whether they like it or not, they must just forget it. We have won with cost, which is what we've been looking for. Even before, it didn't happen, but this time we got it.
Congress intends to appeal the judgment of the High Court of South Africa in Durban. The ANC will be appealing the matter to stop and prohibit the unlawful use of the ANC's trademark, symbols and heritage by Mr. Zuma's party, currently referring to itself as the Umkhonto Sizwe party. In the application considered by the Durban High Court, we relied on Section 34(1)(a) and (c) of the Trademarks Act 194 of 1993 Act to show that the Zuma party is misrepresenting itself as being connected or associated with the ANC by using our well-known logo on its well-known name, Umkhonto Sizwe.
All right, to unpack this case further, we're now joined via video link by attorney Khumisi Kganare. Khumisi, thank you so much for your time this afternoon. So we saw the Durban High Court, of course, dismissing the bid by the ANC in a matter of minutes. I mean, where did the party's argument fall short in as far as it sought to prove a breach of a section of the Trademarks Act?
Yes, I mean, and thank you. There are about two ways in terms of which you can deal with issues of infringement. There's one in terms of the Trademarks Act, which is statutory, and it's very easy. It's a very battle to have, especially when you have a registered trademark that has got a certificate issued by the CIPC. And there's a second way in terms of which you can deal with this, where you don't have a registration certificate and you cannot necessarily fight in terms of the Trademarks Act. And you do it by way of common law, where you can, argue passing off unlawful competition, and. So we know in this matter that there were issues of, ownership and registration certificates insofar as the Umkhonto Sizwe is concerned. What we know also is at least there was a process that has been started already in September last year, where there was a filing of applications to protect, the logo and the name Umkhonto Sizwe. However, just a mere filing of an application doesn't give you, protection. In terms of the Trademarks Act, protection comes after registration. And to get to that point, it's a very long process. It's not a short one. It can take up to 2 years or even 3 years if the process is complicated, where people come and oppose after you have, advertised the mark. So this case in particular was centered around the common law route, in terms of passing off. And that also, is a bit of a steep one, especially where you do not have a registration certificate that protects your logo, your slogan, your whatever brand you may be fighting about. You would have then to go back into history and to deal with evidence and facts around your use, your goodwill, damages, and misrepresentation. And we know that the applicant fell short in that regard.
Now, one would then wonder what, approach the ANC then will take as it appeals. As you've heard, of course, the ANC speaking there outside of that ruling that it will appeal this matter. We know, of course, that only the order was read out in court this afternoon. So without line of sight of the actual judgment, at least from my vantage point, just talk to us firstly, what you foresee the strategy that the ANC then is likely to use, and more importantly, how long and challenging this next approach will be. And I'm very keen to understand this part, particularly as you use those two examples in terms of how you can, argue infringement.
Yes. I mean, bottom line, the ANC is allowed to appeal, the matter. I'm not privy to the judgment and its reasons. But, after having a look at the reasons, they should be in a position to say, but we believe, a higher level of this court where there's 3 people sitting, after hearing us again on these issues, they might come to a different conclusion. If it doesn't go to the same court, it might go then to the Supreme Court of Appeal. And you have about 15 days from today as the ANC to then work on your notice to appeal. Which, after being granted, it becomes a full-blown process again, where there's going to be exchange of papers, there's going to be arguments, and at the end of it all, we get to judgment. The thing with appeal is you cannot go outside of the scope in terms of which you were fighting when you were in the High Court. So you cannot present new evidence, you cannot present new facts. We know there's a lot of facts that were presented and evidence around ANC, building the dots to ownership of the Umkhonto Sizwe, name and style. To say even if we don't own it directly, but there is an arrangement between us and Legacy to then use it, and as a result, then we are the proprietor of this. And over and above, even the history, we have been using this thing for a very long time, and it's our brand. The main question then becomes, how do we then define the area? How do we define the market, if you may? And the market would be, the political space, really, especially leading to the elections, that we cannot say Umkhonto Sizwe as we know it will be competing against the Umkhonto Sizwe party. They will be on the same ballot. When you have a look at the ANC logo and you have a look at the Umkhonto Sizwe party, they are not confusingly similar. So you really have to convince court that this will likely confuse the market or the voters, and as a result, it's infringing also on our reputation and the goodwill we have built over time. But we saw they fell short in that respect.
And given then those parameters that you talk of, how likely then is a success come appeal?
Yeah, it becomes the prospects are low, but you'll never know what happens at the next level. But just looking at it on the face of it, prospects are low. Especially when we have recourse to what has been, divulged already in terms of evidence, facts, and the big issue here is there is no certificate that relates to the Umkhonto Sizwe being owned by the ANC. At least, yes, we know it's a fact now that there is a process underway which seeks to then produce a certificate at the end of it, and it only started last year, September. Getting certificates will not be something that happens anytime soon.
And of course, as you said, that matter was not before the court at the time. So now the issue of ulterior purpose, by the ANC was brought up by, of course, the MK's legal representatives. The fact that the ANC delayed in bringing this matter to the High Court, given the time that the party was registered and only chose to act in January. To what extent did that negatively impact on the applicant's case, do you think?
Yes, it's somewhat of a side issue, but still important that they could not, prove agency. And, ordinarily, if you cannot tick that box, then, your case gets affected drastically before we even get to the merits. But fortunately, even merits were dealt with in this matter. So whether or not the matter was urgent and they delayed is neither here nor there. Because even when we now cross that leg and we get into the merit of the case, they still fell short.